Today is a special day. Today we are having a match between India and Pakistan, and for India we are both dressed in blue. And yes, important subject today. That what is the power of mediation, and how can we as professionals, as part of the whole ecosystem, use mediation, understand the mediation law that came in recently, and use it for our professional and other benefit in the IBC. Over to Anil sir.
Thank you, Ankit. With the blue jersey, we both are trying to say that we are wishing all the best to Indian cricket team for a match. Today we have a little lesser audience because everyone is trying to catch up to the television, because see, this is also a virtual inauguration today for the World Cup, and the program actually will start at about 12:30, and we have less audience. And then yes, we also have to just get glued to this event, which is historical event. And for, I think this is after about 7 years that India and Pakistan is playing on Indian soil. So that's really a great event for India. And we also wish that this particular kind of event will also kind of develop some good relationship with our neighboring countries. So the coming to the subject, back to Ankit, we are today trying to give a preview of the new Mediation Act 2023, and why we are saying that, one, that this Mediation Act 2023 will also have some role in the insolvency and bankruptcy law. This will also help in some kind of disputes under the Companies Act. And as you understand, the pressure on the NCLT and NCLAT will also be reduced to some extent with this mediation law. Not only this, what we understand that our audience, the participants, would also like to understand the opportunities in this new law. We still recall when the SARFAESI law came, so we actually could understand the opportunity. When the insolvency law came, we could understand the opportunity. And now this mediation is also coming. So there are mediators, there are mediation service providers. Of course, the council will be set up by Government of India. So the council would be important, but then the most important part for people like you and me, for us, would be to want to become a mediator, and also to establish a setup which is considered to be a mediation service provider. Now, this mediation service provider is just like IPE, and we will see whether it is possible to have this kind of mediation service provider. Mediation service provider will be providing the secretarial support, infrastructure to mediators, and also will empanel the accredited mediators. So this is, Ankit, the objective that we actually would like to see today, that this is the kind of thought that we had. Today would be a day when we are just giving a preview. We will not stretch too long, because we will have to finish little before 1 hour today, because of this various people will have to rush and glue to, because see, all the televisions will start much before our program ends today. But yes, we will share our PowerPoint presentation, and for this 79th episode of AAA weekly webinar series, the subject is the new Mediation Act 2023, and we will also try to see how it will help reduce the burden on the NCLT, NCLAT, and how our insolvency professionals, advocates, chartered accountants, company secretaries can use this opportunity. So, sharing my screen. Okay, so we have named it as the interplay between mediation and IBC, and interplay not that it is already an established interplay, but what we are trying to say that this is what is possible. Now, like when we say that the mediation as an effective alternative dispute resolution mechanism, that is not a new thing. Then what is the kind of essentials of mediation under the insolvency and bankruptcy law? Some relevant judgments also that we have seen, and the global aspect, how globally the mediation law is developed, a little bit of glimpse of those global aspects. So this is our subject today, and more so we would be coming in the next kind of 2 or 3 episodes that will be clause by clause deliberations on the new Mediation Act. So coming to this, like this Mediation Act 2023, it was notified by Government of India on 15th of September 2023, and the law has been structured for the first time. Although this particular idea, the mediation as such, is something which is completely historical. It goes back centuries. And in case we see this Gram Panchayat, which is a village council in English, that Gram Panchayat is exactly something which is called community mediation in our new law. Now, in case the definition of community mediation is seen in this new law, that actually match with this new definition of community mediation. The one very basic difference that I will have to say, the mediation is voluntary, where an impartial third party facilitates the negotiation process between the parties in dispute to arrive at a mutually acceptable solution. The role of mediation in the insolvency process is vital. So, like the basic difference between the arbitration and the mediation. In arbitration, once we appoint an arbitrator, the arbitrator will get a power to enforce his decision on the parties. Whereas in the mediation, there is no such power with the mediator. The mediator can only resolve a dispute if both the parties are agreed to that. Both the parties must agree, both the parties must sign the terms of agreement, then only this actually gets finality. Otherwise, we can say that the mediation failed. In case both parties would not sign, that means mediation failed. In the case of arbitration, once the arbitrator is appointed, that decision would be binding on both, unless the court finally says that in this particular arbitration order, some kind of non-compliance has actually been done. So therefore, mediation is completely voluntary and mutual. No mediator can enforce his decision on the parties. I think, Ankit, the basic difference between the arbitration and the mediation. I think you can add something on this, Ankit.
So that's the basic difference here. It's very much right. But then, what I read in the Mediation Act and what I understand about the Mediation Act is that now we are giving structure to the whole mediation system.
Absolutely.
So far, I understand that I remember one of our clients telling us that yes, their case was pending with the High Court of Delhi, and the judges there referred that matter for mediation. And the mediation cell within the Delhi High Court then tried to do a mediation, which when it failed, then only the High Court took over the matter. So that was in a way a compulsory mediation that certain parties had to go through or have to go through within the High Court process. So I think similarly now they want to expand this process, expand the number of professionals who can, mediate between parties. And I think when we look into this act, we also have now dedicated regulator for mediation, which is something which is very new. So it is basically giving a parallel system with respect to if two people are having a dispute, rather than going for litigation, they can go for a pre-litigation mediation. And if that mediator is able to give them some terms at which both of them agree, then they can avoid legal costs, they can avoid the court's time. So I think it's a landmark legislation in the sense that in future, I understand that certain professionals will get the status that they are very good mediators, and they are having this capacity or capability to reconcile two difference of opinions. So rather than having long and challenging litigation, we can maybe, some people will try to resolve the issues through good mediators. So that's a new profession which is likely to come up, which will be separately regulated. So I believe it's a great question, and of course the arbitration versus mediation. I believe, yes, that's something which is the obvious difference between the two.
So yes, Ankit, in fact, in India, this alternative dispute resolution ADR system, in fact, the India started working on this format back in 90. And in fact, the 129th Law Commission report in India in 1988 recommended the introduction of conciliation court system for several litigations. In fact, in case you would see in Delhi High Court, there is a separate cell, mediation cell. So many times when you file a commercial dispute, when you file a trademark dispute in Delhi High Court, they will say that first you try mediation, and then there is a mediation cell, and then there will be mediators, and those mediators will try to mediate the dispute, and in case the mediation is failed, then we go back to the same court. So that's where the present system is presently prevailing. In fact, in Singapore Convention, United Nations Convention on Mediation in 2018, they actually finally resolved that there should be an encouragement on settlement of disputes through mediation under various Indian laws. In insolvency law, because I have seen in 2017 there was a working group on individual insolvency, and where the IBBI committee recommended that the code should provide for a time-bound mediation process which recognizes debt negotiation and settlement framework. But then this particular report, the August 2017 report, also recommended the recognition of new cadre of professional mediators. That recommendation has actually fructified now by way of this new notification on 15th of September 2023, which is the notification of the new law, the Mediation Act 2023. Now, this concept can be used for insolvency cases as well. Now, the Mediation Act 2023, let us see what is the preamble. The preamble of this Mediation Act, which is there in the Act itself, that is something which is, just a minute. I will just smaller the picture. Now, the preamble is to promote and facilitate mediation, especially institutional mediation for resolution of disputes, commercial or otherwise, enforce mediated settlement agreements, provide for a body of registration of mediators to encourage community mediation and to make online mediation as acceptable and cost-effective process and for matters connected therewith. Now, this act has actually got 11 chapters, 65 sections, and 10 schedules. Now, this legislation actually is applicable to kind of primary means of resolving various kinds of civil, commercial, family, and community disputes. So when we say the civil, commercial, all these disputes, so like there are various things that I would like to say. So the definition of and scope of mediation in India is actually there in section 3, and which says mediation includes a process whether referred to by the expression, mediation, pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import, whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person referred to as mediator. Now, the word that I have colored as red, who does not have the authority to impose a settlement upon the parties to the dispute. So the very, very important definition in section 3, subsection H, the mediator has got no power or authority to impose a settlement upon parties to the dispute. That means unless both the parties will sign, no dispute can be resolved. The mediator has got no power to impose a settlement. So, Ankit, this is something that I wanted to highlight. And also, Section 4 of the Act outlines the concept of mediation agreements, requiring them to be in writing and involving the parties and their successors. These agreements serve to facilitate the submission of disputes to mediation, either as clauses within the existing contracts or as a separate contract. Now, whether the existing dispute is out of an agreement, whether that agreement has the mediation clause or not, separate agreement can be entered. Whether that agreement, maybe it's a lease agreement, maybe it's a rent agreement, maybe it's a loan agreement, it is irrelevant whether the original agreement has a mediation clause or not. The parties can decide that they can go for a mediation and they can appoint a mediator. Pre-litigation mediation is a concept introduced in Section 5 of the Act, enabling parties to engage in voluntary mediation for the settlement of civil or commercial disputes. So it has to be civil or commercial disputes before initiating formal legal proceedings. And you would see gradually that the courts would not entertain suits directly. The courts will always say, have you gone through mediation or not? In case you have gone through, provide us the documentation and attach that as a part of the pleadings or as part of the application. In case you have not gone for mediation, try mediation, and then we will see in case the mediation will fail. So this is something which is going to be the importance of this particular law. Now let us understand who can conduct the pre-litigation mediation. A mediator shall conduct. Now, what is the mediator? Mediator is a person actually who would be registered with the council. So there is a proposal in this Mediation Act 2023 that the Government of India will set up a council. We will have a definition. There is a council which is completely defined how the council will be set up. There will be 7 members. Who all will be the members? How many members will be appointed by the government, and how many members will be? So these are all, there is a structure of the council. Then the mediator will be empaneled by a court annexed mediation center or empaneled by an authority constituted under the Legal Services Authorities Act, empaneled by a mediation service provider recognized under this act. Now, this mediation service provider is just like an IPE. So these mediation service providers can be any private party. So this is where the first opportunity. Second opportunity, of course, as a mediator. And this mediation will become a kind of precursor to all litigations. Now, in cases involving compensation claims under Motor Vehicle Act, parties failing to reach a settlement are referred to the mediation. This is what has been happening. So what we are now saying is that the Section 6 of this Mediation Act 2023 states that the mediation cannot be conducted in the matters listed in the first schedule of the Act. So primarily, if you will see all this, you will see that basically the requirement is that both the parties should be of a sound mind. Both the parties must be alert. Both the parties must understand what kind of decision is being taken and how they are providing their mutual consent. These are the prerequisites of Mediation Act, because nobody else is thinking on your behalf. You both are, both the parties, or all the parties to a particular dispute are thinking for their own options. They are thinking about their own options and what kind of a decision would be best for them. Therefore, the Mediation Act is not applicable to disputes relating to the claims against minors, because the minor would not be able to decide about his part. Similarly, person with intellectual disabilities, persons with mental illness, persons of unsound mind, suits for declaration of title against government, disputes involving prosecution or criminal offenses. Because the prosecution or criminal offenses, because these are the state-initiated litigations, cannot be decided through mediation. Complaints in relation to registration of anything, because the registration is again something which is one part is government or one part of one agency, discipline, misconduct of any practitioner or any registered professional, such as legal practitioner, medical practitioner, dentist, architect, chartered accountant, or in relation to any other profession of whatever. So while this particular act was being drafted, government thought that all these kind of disputes, which actually is good or bad for the society, like you can't say that the doctor actually was negligent and then the doctor in fact caused a death because of the negligence, and finally this can be settled through a mediation. That's not the objective of this law. Then disputes creating third-party rights, like in case 2 or 3 parties mediate together and they actually create third-party rights, or they decide something which is impacting on third parties, that is where the mediation is not applicable. Disputes falling in the ambit of National Green Tribunal, because that tribunal is totally different. Disputes related to the direct or income tax or refund or direct or indirect tax or refunds. Inquiry under the Competition Act and Telecom Regulatory Authority, proceedings before the Petroleum and Natural Gas Regulatory Board, proceedings before 𝐓𝐨𝒂𝒚, and land acquisition law disputes. So this is the part of the first schedule to the Mediation Act 2023, which actually enlists all those areas where the mediation is not applicable. Then Section 7 of the Act says the court, tribunal at any stage of the proceedings may refer the parties to undertake mediation. I said that. Gradually, you will see, since this law has come, a structure will be set up, a council will be made, the mediation service providers will be created, mediators will be created, and then you will see that the courts will always say, in most of the cases, the court will say that go and first have the mediation and then come back to us. This is going to happen. An application shall be moved under Section 8 by a party seeking initiation of mediation to a mediation service provider. Now, this application is also not going to a court. This application is going to a mediation service provider for the appointment of a mediator. The mediator service provider shall, within 7 days, appoint the mediator as agreed by the parties, and in case of a non-agreement, any mediator can be appointed from the panel. Any mediator can be appointed from the panel in case there is no agreement. Because in case that's not really important, like who is the mediator. If a mediator is intelligent, if a mediator can actually try to find out how the parties can reconcile with each other, that's the best intelligence of a mediator. But mediator cannot put a pressure on anyone, because the mediator has got no power to pass an order. Section 18 affirms that the central government designates authorized entities for this mediation, which must be completed within 120 days and which is maximum extendable to 60 days, for 60 days. So that means 120 plus 60. So this maximum mediation period will be 180 days. In 180 days, it can be concluded. And in case it fails, it go back to the dispute. Now, the one part, which is a very, very important part of the mediation, is confidentiality. Now, this act, in fact, reinforces that the confidentiality is the very, very big ingredient of this mediation process. It is very clear that anything disclosed by the parties during the mediation process would not be used against them in the court. In the litigation, in the post litigation, like post mediation litigation, all those documents, all that information which is provided to the mediator or to the other parties would not be used as an evidence or against the other parties. Of course, this will have some litigation on it, and what kind of litigation it will be, whether there are some information which is otherwise available with the other parties, that is not the information which was only and only provided during the mediation part of it. Now, the Act also have provisions regarding online mediation under Section 30 of the Act. Online mediation, including pre-litigation mediation, can occur at any point during the mediation process, provided that all the parties give a consent for online mediation. Act also, Section 31 of the Act also establishes Mediation Council of India, responsible for one, overseeing and regulating mediation services. Like we have already seen Insolvency and Bankruptcy Board of India, IBBI. Now we will see MCI. And there is one MCI is Medical Council of India. Now this will be the Mediation Council of India. Mediation Council of India actually would be set up by government. In case we see the members of the Mediation Council, in fact, there are 7 members, and most of all these members are like, there is, we'll come to that.
So before we continue, I think I can ask some questions that have come in. So, Mr. Samant Pradeep, he's asking whether we can appoint a mediator as on date and what is qualification of a mediator. So here, this act has been passed by the parliament, but it has these days with all such acts where an authority like Mediation Council of India is required to be set up and empaneled mediators have to be empaneled. The way IBC started, I think we all can relate to it. So different sections are notified at different points in time. So here again, the Mediation Council of India, after this act has been, after this bill has been made an act on 15 September, that notification came in. The government must be working on creating a Mediation Council of India, and then subsequently the qualifications of a mediator, the way the empanelment will happen, and all those processes will start. However, the current system of mediators, which is already going on as an exease to the high courts, that I believe is already continuing. So that is still available as on date to people. So apart from this, I have another question from Mr. Arun Kumarji. He says how Mediation Act 2023 is different with provisions of Section 442 of the Companies Act. So here, Arunji, the Mediation Act 2023 has also provided for modifying the Section 442 of the Companies Act. The way IBC modified a lot of provisions in other acts. Mediation Act 2023 is also modifying many acts, including Section 442 of the Companies Act, such that mediation under Companies Act will now also be done under the Mediation Act or read with the provisions of Mediation Act 2023. So that is how this structure will happen, that Mediation Act will govern all the mediators, the regulator will govern all the mediators, and different acts will then refer to mediation. Wherever they refer to mediation, they will refer to Mediation Act 2023 for it. Then we have a question whether what is the difference between Arbitration Act and Mediation Act? So before Mediation Act became an act, Arbitration Act itself contained the words mediation and conciliation.
No, it was arbitration and conciliation. The mediation word was
but what I'm trying to say is that mediation was part of the act. Mediation was also one of the chapters in the act. So now what they have done is, when mediation, if we read Mediation Act 2023, it also amends Arbitration Act to remove the words mediation and conciliation, such that the Arbitration Act will now be restricted to governing the act of arbitration. So this is how the act is structured. The Mediation Act. So it changes the Arbitration Act also. So it is basically carving out mediation as a full-time, as a different act and as a different profession, which is governed differently, and it is a separation now from the Arbitration Act. Then we have a question from Mr. Mr. Kabir, he says, is it that no dispute where government is a party cannot be subject to mediation? The exclusion list is somehow conveying such a feeling. So is that the case that wherever government, I don't think that's the case. I think it's
No, I
something to do
think
with,
it is not linked to the government. It is linked to the direct and indirect taxes, and
right.
there are specific areas where it has been excluded. I believe if the any government agency like the
Well, very, very simply, let's talk about traffic challans. The traffic challans, these lok adalats and mediation is working, and that's against the government that you have a legal process with the government. But there is a process of mediation where somebody goes, says that, okay, maybe I
I
made a
believe
mistake.
PWD, CPWD, all the dispute can be resolved through mediation.
Yes,
I
that's also
believe
there.
that because the
Yes.
government on one side is not a kind of debarring the process of mediation. Yeah, that's not which is I think.
Then we have a question that is IP eligible to get registered as a mediator. So I think
No,
maybe
that
no,
is
maybe
something
no,
no. That is
maybe no.
clear
But
no.
IP's own qualifications, I believe, might make him eligible to be a mediator also. So an advocate perhaps will be an eligibility to be a mediator, and subsequently the Mediation Council of India might have a process of taking an examination, making some kind of a course, the way IBC has certain stipulations. Another question that can check bounce cases be referred to mediation? Check
The
bounce is more of a
check bouncing
criminal.
is a criminal case, and
Yeah,
wherever wherever any kind of fine or any kind of prosecution, any kind of imprisonment is provided in the law, that cannot be resolved through mediation or even arbitration, also. Because see, this is very important to see whether the when the state becomes a party. Because in all these, although this 138 cases, the law uh, provides for a imprisonment, cannot be mediated.
right. Then Mr. Iswara Pillai, our partner, he's asking whether Medical Council of India will be under which ministry. So the Mediation Act has been notified by the Ministry of Law and Justice. So maybe the same ministry will continue governing the Mediation Council of India as well. Then we have a question from Ms. Pallavi Agarwal ji, who's asking that who will be eligible to be a mediation service provider. So, can mediation course with ICAI, can it give some kind of eligibility for the same? I believe the Mediation Council of India, whenever it will be set up, may not recognize or may recognize a mediation course done by ICAI. I'm coming on this, or I'm talking about this because when we did valuation course from ICAI, we thought that maybe at some point in time it will help us get legal permission to practice as a valuer. But later, when the valuation standards or the valuation under Companies Act it came to IBBI, then IBBI started its different process. So yes, the know-how that one had through that course does help, or continues to help. But maybe the legal eligibility to continue as a practice may not be available. We will see as and when these details come out. So, majorly, I believe I have taken up all the questions, and if, yeah, I think we can continue.
So we go forward as a preview, as we said that we will have clause by clause deliberations on this entire act in the coming few sessions or episodes. However, few things that the cost of mediation will be borne by the parties almost equally in case there are two parties, 50-50, three parties, one-third. The confidentiality is something which is very, very important, because whatever matter, the confidentiality is very important for the mediator and also for the mediation service providers. The parties and the participants in the mediation will keep confidential matters relating to the mediation proceedings. So no party can rely on or introduce as evidence any information or communication. So, in case the mediation is triggered, and it can be withdrawn after first 2 sessions. For the first 2 sessions, if one party doesn't appear or doesn't show up in the mediation sessions, because this is not hearing, these are mediation sessions. In case 2 sessions are gone and one party doesn't appear, then the mediation will be considered as failed, and the cost will be imposed on that party who actually has not come for the mediation sessions. Cost may be imposed at the time of the subsequent litigation on the subject matter. This is, Ankit, very important. Going forward, because today we are only talking about the preview, so we'll be a little faster now. So the objectives of the Mediation Act 2023 is: one is the promoting access to justice, fostering amicable relationship, reducing legal backlog, enhancing privacy and confidentiality, and supporting businesses. Now, mandatory pre-litigation mediation, these are the key elements and challenges. And this is although the requirement that we talk about, the requirement is that it is basically aimed at to elevate the burden on the judiciary. It is also important to note that the mediation is inherently a voluntary process, necessitating the mutual consent of the parties to commence proceedings. However, compelling parties will give rise to additional litigation. So the Article 21 of the Constitution also talks about this kind of mediation, and it is imperative to appropriately amend the existing moratorium provisions within the country's insolvency and bankruptcy code in case we have to use this mediation as the part of the IBC. Because once the moratorium is triggered, then mediation, or even before the moratorium triggers, the triggering of the mediation, that is something which is important. Okay, so all this is the kind of conceptual issues. I will only be referring to something which is important today. Mediation as an effective ADR is also this is something that we actually were referring to 442 section of the Companies Act, which is, and also Companies Mediation and Conciliation Rules 2016. So this particular section 442, in fact, the objective of this said section was to reduce the burden on the NCLT and NCLAT by providing the parties to dispute with an ADR alternative to address their issues. So the central government shall maintain a panel. So based on this section 442, I think the Ministry of Corporate Affairs is maintaining a panel of mediation and conciliation panel. So that's where we see that panel is being maintained. And any of the parties to the proceeding, that's what we are talking about, section 442. And even in some cases, the tribunal and the appellate tribunal also suo motu can refer some of the proceedings to mediation and conciliation panel. Out of that panel, they can also refer to the experts. And then this again 3 months period is mentioned. The company's mediation and conciliation rules is also kind of having 5 steps. First of all, facilitate voluntary resolution of the dispute by the parties, then communicate the views of each party to others, then assist them in identifying issues, reducing misunderstanding, clarifying priorities, exploring ideas of compromise, then generating options to resolve the dispute, emphasizing that it is responsibility of the parties to take the decision. And finally, the mediator shall not impose any terms of the settlement on the parties unless both parties consent that such terms and conditions may be imposed for early settlement. So this the company's mediation and conciliation rules provide for 3-month period, and this will again have some kind of amendment. We will go clause by clause in the coming sessions. Similarly, section 18 of the Micro, Small and Medium Enterprises Development Act 2006 provides an introduction to interplay between the Arbitration and Conciliation Act. So this Section 18 also, where dispute cannot be resolved by conciliation, the council shall either arbitrate the issue directly or submit it to an institution for arbitration. So all these will get kind of activated. MSME Act, the Companies Act, all this will get activated. And even this commercial code, in the commercial code, I mean, we would actually see this. The commercial codes, commercial division and commercial appellate division of High Court Amendment Ordinance 2018 inserted a new provision as Section 12A, according to which a suit relating to any commercial dispute cannot be filed under the Act unless it is very urgent interim relief before first utilizing the remedy of pre-institution mediation. Now, all these ordinances and all this will finally merge into this overall law. And the Supreme Court also have actually favored in this. Just a minute. The Supreme Court has also favored, like in case they see the Patil Automation Private Limited and others versus Rakheja Engineers Private Limited, decided that statutory pre-litigation mediation under Section 12A of the Commercial Court Act is mandatory, and that failure to comply with this section may result in the rejection of a suit under Order 7, Rule 11 of the CPC. So this is where the design of all this is very rare. And again, the reference has been seen in the RERA, where the Section 32, subsection G of RERA Act 2016 allows for peaceful resolution of issues between promoters and allottees via the use of a dispute resolution forum established by the organizations. Then Industrial Dispute Act appoints conciliators to arbitrate the settlement of industrial dispute according to the established procedures under Section 4. Similarly, the Section 74 of the Consumer Protection Act, the state government has been given authority to create a consumer mediation cell to be connected to each district. So what I'm trying to say, Ankit, all this will finally get merged into this particular law, and with this kind of framework. And in this framework, there'll be a council, there'll be a mediation service provider, there'll be a mediator. So all this will finally get merged. Presently, there are various fragments that we can see in the Consumer Protection Act, the Industrial Dispute Act, RERA Act, MSME Act, Companies Act. So what I'm trying to say is that this is where we actually find an opportunity, and that opportunity is likely to be seen in the coming months. Yes, Ankit, in case there is any few questions, or we can move to the next chapter.
We can move to the next chapter, and I could totally agree with you that the whole idea is to set up, mediation institutions, mediation centers, mediation empaneled mediators, so that and bring mediation in the process, so that wherever litigation is supposed to happen, before that a mediation can happen. And in times to come, in the West, we see mediation working wonderfully well, primarily because the cost of litigation has gone up there and mediation comes to rescue there as a low-cost solution. In India, however, when we see arbitration or when we see mediation, we still rely or choose to rely on a more powerful judgment from the High Court, Supreme Courts, and so on, from the tribunals. So here again, when we talk about mediation, we are, of course, looking at maybe solving, the success of mediation in India will be depending on what percentage of total disputes are resolved at the mediation stage, where they don't need to go to, a judge to pass orders on. And that is a question, that how many of those will be resolved.
But Ankit, in the coming months and in the coming sessions, we will be discussing a couple of things. See, for an arbitration case, for an arbitrator, passing a judgment which is not compliant to a law would be difficult. However, in mediation, I believe the law of equity would not be applicable. I believe the non-compliances of any of the law of India would not be applicable. What is more important is the mutual consent of both the parties, and also that both the parties are of sound mind and they can actually look after their interest. So this is the only thing that we have to decide. Even if somebody says that as far as the law is concerned, according to law, I'm entitled to say 1 crore. However, in this particular judgment, I'm only getting 25 lakhs. So that would be, once I sign, and I sign it with my sound mind, and by considering all my options, I believe that will be a valid resolution, isn't it?
Yes, that will be valid, but the question is that how many of the people will actually go for that final settlement? So, what happens internationally is that, say, a company is a large corporate is associated, or it associates a law firm as a mediation cell. That law firm goes out to the plaintiffs where the company has certain consumer complaints against that company, and they propose a settlement where they say that, okay, we will pay you this much, you settle this dispute. So internationally, that kind of a process is adopted by corporates so that the cost of their litigation goes down, where they are not supposed to pay for the lawyer fees. And at the same time, from the customer's end, the plaintiff or the customer who is aggrieved, he also gets a decent, windfall. But there again, the concept is also that many advocates in the US, let's say, would take on a case on a fee sharing system that, okay, if we are able to realize 100 $10,000 from this litigation, then 5,000 will be ours, and they, do that, handle that case in that way. But that practice is not, really there in our country. So that's the only question, that how much will this be accepted on a day-to-day basis, and what was the number of cases or the litigation that will reduce. But I think the government, by passing this Mediation Act, is showing confidence that this will resolve the number of, or reduce the number of litigations. Mediations happen anyways, like family mediations. We are party to so many families who have had, some common relative who both of them trust, and that person is mediating for two brothers or having a dispute. So that's already there. But then this is a more organized way of handling the same problem.
I think few of the essential roles of the mediator, like the mutually opposed claim, he will have to understand, he have to pacify the parties' egos and feelings, and then finally storing corporate relationship, efficiency, goals of efficiency. And all this is basically the benefits are all that it preserves the relationship also. Even the Supreme Court of India has referred this Ajodhya dispute to mediation. And in the like in another case, like this Mr. Krishna Murthy versus New India Assurance Company, impressed the government to also consider the feasibility of enacting Indian Mediation Act to take care of various aspects. This was also the Supreme Court, in fact, has said in 2019 that the government of India should do that. So the government of India has now done it. So the Supreme Court, in fact, observed in that case that mediation is here to stay, it is here to evolve, and it is because of the advantages of mediation as a method here to find new ground. So this is what exactly the mediation, the background is. Then we can actually say that some kind of insolvency cases also, maybe some Section 9 cases, maybe that some kind of changes, some tweaking would be required, that before somebody comes to file a Section 9 application, there can be a mediation, pre-litigation mediation, and so that it becomes a win-win situation for everyone. Because see, in a mediation, no party wins or loses. Because see, there is, unless both sides, mediation fails. So this is where we actually we are trying to say that these all preambles that we are saying, how the mediation will finally erupt gradually. So we actually will have to see something which is the more important, global aspects. So in case we see the global aspects, in USA, the mediation for insolvency cases was introduced in 1986, and the country had started using the same in case of insolvency in the year 1998, where the ADR, like Alternative Dispute Resolution Act, was adopted. So the USA has been using mediation quite frequently, and it has proven to be very successful. courts in United States have set up court annexed ADR program. In our case also, there are two kind of definitions. In case, in fact, I have not completely read, but whatever I have read, there are community mediation, then there are kind of institutional mediation, then there are international mediation. All these are defined in this particular act, in the act. And so the in this then there is a court annexed mediation also, and independent mediation also. So these are various things which actually it's coming to India also. European Union also, pre-insolvency resolution of disputes, that's also there. Under the French insolvency law, two procedure conciliation and ad hoc mandate are provided. In German insolvency law, it allows the creditors and the debtor to negotiate an insolvency plan. In Italy also, the insolvency system provides several options for businesses in financial distress to restructure their debt. Similarly, in Singapore, it's like Singapore also recommended use of mediation in insolvency resolution to transform into an international insolvency resolution hub. I believe when this amendment will come in the IBC, this amendment, which is expected, and in the next session, you would see some changes, because see, now this Mediation Act has been notified. So IBC will also have some part of it which actually will be using the Mediation Act. So that's also, which is kind of is possible. Spain is also this, it is very popular. United Kingdom, it's again mediation is very popular. Japan also, its mediation is very popular. So like we actually can see this Lehman Brothers holding, these are some of the judgments of USA, which is also like, but then today what we are trying to say, all these international judgments, and finally we can say this mediation is going to stay. It is more of an opportunity for all of us. Therefore, we have decided that we will be doing a clause-by-clause deliberations in the coming few sessions. So, Ankit, I think we have this much only for the day. And anything that you would like to add?
I will quickly answer some further questions that have come in. So, one question is, can pending mediation be cited as a delay for to delay the CRP admission? So, in case of an OC claim, then OC related litigation, mediation can also be understood to be mediation on some kind of a dispute. So it will be up to the parties to try and talk about what the mediation is about and whether it is about any dispute relating to the pending payment or it is dispute free. But then yes, a pending mediation can be understood to be a dispute as well. Then of course we are talking about the time limit. So generally there is a time limit that is agreed in the mediation contract when it is entered into. It can be 1 month, 2 months, depending on the time that the parties agree to, and then it may be extended only after the parties agree to that extension. So normally it's a time bound process. It is not left open. I believe arbitrations normally don't have any time barring. They can go on for a longer time. There again, some arbitrations can have a time barring, but I believe most of the arbitrations, many arbitrations that I know, take a long time. So mediation, it can be limited by time, and if either party say no, we don't want to continue, then it can stop.
So I think we can conclude in case there is no further questions. And as we say that we are finding an opportunity, so we will be coming with few sessions on this.
Yes, for certain.
So finally, wishing Indian cricket team a win today at Ahmedabad. So with this, we can say thank you very much, participants, for joining this episode. Thank you.
Thank you, everyone. Thank you so much. See you next week.